All right, so I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
Thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence, but the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad legal information in the jail since we were last here in court. But that shouldn't change the fact that Mr. McGee has had no criminal history.
Right away, the defense is trying to frame this as a tragic first-time mistake instead of the actions of a hardened criminal. No prior felonies, no prison history, no probation record. That matters in sentencing. Courts often look at whether someone is a repeat offender or somebody who completely spiraled in one catastrophic moment. But here's the problem. Judges don't just sentence based on background. They sentence based on what actually happened during the crime.
Other than some traffic citations and a few failures to appear on those traffic citations before this, he's never been in our system. He's never been on probation before, never been sentenced to prison before because he has no criminal history. Mr. McGee did not live the same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin would typically put himself before others, and he had a very rough childhood. His mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life, and that's not my words. Those are the words of close friends and family members that have kind of written on his behalf. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of, and the violence that took place in the offense. While my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day, I will say that he was not the aggressor or the main aggressor in the situation. The crime that they committed was despicable, and he would agree with that. He thought that he was going over there to retrieve stolen property. He didn't.
And this is where the defense rolls out the rehabilitation argument full force. Rough childhood, absent parents, trauma, religion, newfound purpose, even the hope of building a relationship with his son. Legally, this is mitigation evidence, basically asking the court to see the human being behind the charges. But prosecutors know something too. When violent video evidence exists, emotional mitigation becomes a much tougher sell. And viewers, ask yourselves honestly, how much should a tragic upbringing reduce responsibility for a violent crime?
Not know that his brother was going to start shooting. And in visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found religion. He has, one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups that he had. He also had a jumper malfunction with his buttons. But he says that his newfound religion has given him discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. The child is 3 years old. And he would like to have some sort of a life with a son. I would suggest that he get 10 years deferred adjudication probation, and if he messes up even 1 iota, he's got the full range to deal with. So I would suggest that he get 10 years deferred probation, be put on intensive supervision, 0 tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not, and I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad
No, I'm
information.
not worried about that.
Yeah, he got some bad information in the jail, but he is eligible for probation. I would ask that he get probation, and I'd give Mr. McGee a chance to address the court and explain why he should get probation.
First and foremost, I would like to apologize to the victim in my case. I didn't know, like just my lawyer said, I didn't know that my brother was going to go over and sue him. He told me.
Hang on a second, Devin.
Whoa. The entire tone of the courtroom just changed. The judge cuts the defendant off almost immediately and makes it crystal clear she has already watched the surveillance footage multiple times. And when a judge says things like, "I saw you egging him on," that is devastating for the defense. Because now this is no longer just about legal theories or excuses. It's about the judge personally believing the video contradicts the defendant's version of events.
Just stop. All right. Y'all went over there with a gun. Hang on. I've watched the video. And you were the one who egged your brother on the entire time. I'm not even sure that your brother would have done what he did had you not been there, just in his face. Do it, do it, do it. I've seen it. Hang on. I've seen it. There's probably nothing you can say right now that's going to help anything, because all you're doing is trying to not take responsibility instead of taking responsibility. Ms. Malfino.
Thank you, Judge. You just took the words right out of my mouth.
Sorry.
For having no criminal history, we saw him go from 0 to 100 in a matter of 2 hours. On behalf of the Jones family, we appreciate the court taking the time when we addressed Tevin's case to carefully consider all of that evidence. This is a unique situation where I don't even feel like I need to argue the PSI. You have everything in front of you. I know you recall it. I know you remember it. I know you know the violence there, and he was responsible for those actions. He needs to be held responsible. I appreciate Mr. Nick's argument. I respect him immensely as a professional. He's just doing his job. The words probation are just absolutely.
Listen carefully to what the prosecutor says here. This is not a gift to Devin. This is a gift to them. That line is powerful because it flips the entire conversation. The reduced exposure isn't being described as mercy for the defendant. It's being framed as mercy for the victims, so the family doesn't have to relive this nightmare through a full trial. Emotionally, this may be one of the heaviest moments in the hearing.
Ludicrous for this case. I think Jason said it best when he told you this is not a gift to Devin. This is a gift to them. To let this be over, to stop the nightmare. They deserve to have some peace from this. Your brother's gone for the rest of his life. You better be glad that your exposure is 30 years, and that's not a gift to you. That's by the graciousness of this family. Judge, on their behalf, I respectfully ask 30 years with an affirmative finding Devin.
Can I present the 2 letters?
So, I appreciate Mr. Nick's argument. I appreciate these letters. The problem with these letters is I don't know. I wish if they hadn't seen that the people who are saying what a good person you are and how much remorse you supposedly have, and that you've taken responsibility, saw the video of what happened that night.
And this is why video evidence changes everything in criminal court. Most cases rely on conflicting testimony, witness memory, or police reports. But the judge is basically saying, I didn't just hear about it. I watched it happen. That gives the court a front row seat to the fear, chaos, and violence of the crime itself. From a legal standpoint, video evidence can completely destroy mitigation arguments because the judge sees the defendant's actions firsthand instead of through competing narratives.
Not a whole lot of times here in court that with cases, we have the opportunity to have pretty much every single part of an offense on video, right? And that makes this unique. It's unfortunate probably in some cases that we don't, because probably other people who've done similar things get maybe some breaks that they shouldn't, because we don't have all of that. What you and your brother put that family through that night is the stuff, and I think I've said this before, the family's probably heard me, I know, tell your brother this. This is the stuff out of a movie. This is what makes people have nightmares at night. And you instigated it. You walked with your brother with that assault gun, however far y'all had to walk, knowing you weren't just going to get property. holding a
I
gun.
objected.
Well, you can object whatever you want.
This might be the most damaging statement of the entire sentencing hearing. The judge says she remembers seeing him show his brother how to take the safety off the gun. That transforms the defendant from someone merely present at the crime into someone the court views as actively escalating the violence. And once the judge reaches that conclusion, probation was never realistically on the table anymore. By this point, the courtroom atmosphere feels less like a debate over punishment and more like the inevitable countdown to a massive prison sentence.
But I know what I saw. I know that you instigated him to keep doing it. You showed him how to take the safety off the gun. I remember all of that. So at this time, I'm going to find that you entered a plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time, I'm going to find you guilty of burglary of a habitation with intent to commit aggravated assault. I'm going to sentence you to a term of 30 years in the institutional